taken time, and I call the honourable member for Banks.
Well, thank you, Deputy Speaker, and I'm very pleased to have the opportunity to speak on these important amendments to the broader suite of migration legislation that we have in this parliament. And I think it's important, Deputy Speaker, to reflect a bit at the outset about why immigration is important and why it is such a fundamental part of our society. In my electorate of Banks, Deputy Speaker, more than half of everyone in my electorate has at least one parent born overseas. And people in Banks have come to Australia from all parts of the world. The largest number of people of Chinese background of any electorate in Australia, Deputy Speaker, people from the Middle East, Europe and many other places. And the diversity of our community is one of the things that makes it so great. And it's one of the things that makes Australia such a great place, that we have a diversity of culture. And the only thing that really matters in this country, Deputy Speaker, is not your origin, your country of origin or your religion, but the fact that you participate in our society, you play by the rules of Australia, and you make the most of your citizenship. And that is why our immigration program has been so successful. Because immigration, Deputy Speaker, I think comes down to two sets of policy priorities. One is national self-interest. By driving a strong immigration policy, we help to improve our economy. We have many areas of the economy where immigration has helped to build industries going back as far as the Snowy River scheme, of course, and more recently in many industries, IT being a prime example, Deputy Speaker. And so that economic core of immigration is fundamental to it, but so is the humanitarian aspect of our immigration laws, Deputy Speaker, because as a wealthy country, we do have an obligation and a responsibility to help people from some of the most devastated places in the world, and we have a strong tradition of doing just that. But in order to do that, Deputy Speaker, and to be able to provide that compassionate relief for people who are really fleeing some of the worst places on earth, you need to have control over your system, because at the point at which you throw your hands up in the air and say this is all too difficult to control, you lose the integrity of the system, you lose public support for the system, and you lose the capacity to actually effectively manage your own borders. And that is something that this government will never allow, Deputy Speaker. Now, we've been in office, of course, for just on 1 year, and I thought it would be useful to reflect on some of the achievements in that time, and they have been very, very substantial, Deputy Speaker. Now, as I said before, to have confidence in the system, we need to have confidence in the integrity of our borders. We did see under the previous government extraordinary mismanagement. One of the greatest examples of mismanagement of the Rudd-Gillard-Rudd governments was its failure on our borders. Of course, Deputy Speaker, in the 12 months prior to the last election, we had 400 unlawful maritime arrivals, 400 boats arrived on our shores. And let's not pretend for 1 minute, Deputy Speaker, that there is any humanitarian benefit from such a system, because we know that under such a system people place their lives in peril at the hands of unscrupulous people smugglers, and we know that most of those, the vast majority of those journeys ended in heartbreak and despair. And we also know that for people who were in camps and in other locations overseas waiting for a refugee place, that they were directly disadvantaged by those boat arrivals, and we'll come to the special humanitarian program in a minute, Deputy Speaker, where that was most clearly seen. But since we've been in office, Deputy Speaker, not more than one boat arrival since Operation Sovereign Borders commenced. Only one boat since December, Deputy Speaker, has reached Australian shores. 400 in the last 12 months of the Labor Party, one since December last year, when Operation Sovereign Borders commenced. Now, that is a very, very substantial difference, Deputy Speaker, and it is something that this government is justifiably proud of. There's an important economic benefit too, Deputy Speaker, because when you have control over your borders, your requirement to detain people in detention is obviously reduced. And as a consequence, we've been able to close down 4 immigration detention centres, Sherga in Queensland, Port Augusta in South Australia, Leonora in WA and, of course, Pontville in Tasmania. And the benefit to that, Deputy Speaker, is close to $100 million per year. It's about $90 million, the economic benefit of closing down those detention centres. Nobody wants detention centres in operation, Deputy Speaker. What we all want is a situation where people are not arriving illegally, they're having their applications assessed on their merits, and consequently detention centres become less and less relevant. And we've already seen that with 4 of them closed down at a benefit of about $90 million a year. And the other point, Deputy Speaker, is very important humanitarian dividend that we've seen from the activities of the government in the past 12 months. Now, of course, you're familiar with the special humanitarian category of visa, and this is people who don't quite comply with the strict definition of a refugee under the UN Charter, but nonetheless are often in desperate circumstances, often waiting in refugee camps in the Middle East and other places for perhaps technical reasons. They don't comply with the rules for being a refugee, but nonetheless are really in a very, very bad way. Now, under the previous government, because the refugee intake was so overwhelmed by illegal boat arrivals, the number of people who came in on special humanitarian visas had stopped to a trickle, less than 500 a year. And these are people, Deputy Speaker, who are following the correct process, waiting often in a refugee camp in an appalling situation, but for some reason don't quite comply with the definition of a refugee. And those people were very badly done by the Labor government, because that group had admissions had slowed to a trickle because the places were taken by illegal boat arrivals. Now, we've changed that, Deputy Speaker, and it's back up to 4,000 per year under the special humanitarian process, Deputy Speaker, and that's something which is a great humanitarian benefit. Now, it is important to reflect, Deputy Speaker, on what the opposition thought about the government's border protection policies when they were implemented. So if we cast our mind back about 10 months ago, back to November, and you'll recall at the time there was a lot of discussion about whether the government's border security policies could work, whether it was in fact possible to stop the flow of unlawful boat arrivals, and whether in fact it was possible logistically, technically, legally to turn boats around as we had said we would do. And if we actually go back to the 9th of November last year, Deputy Speaker, the Shadow Immigration Minister, he said, "We have had Indonesia from day one saying they won't accept towbacks. It is inevitably going to fail," and that's what we saw yesterday. So that was in relation to turning boats around back in November. And indeed, on the same day, the opposition leader, there's no doubt in my mind that the coalition's boat person policy is absolutely not working. Leader of the opposition, 9th of November 2013. Now, I suspect he would revise those comments were he to make them today, but they do demonstrate why leadership is so important in this area, because the government did take some very difficult decisions, but they have been very successful and they have had a humanitarian benefit. We know, of course, Deputy Speaker, the record or lack thereof of the opposition in this space, $11 billion blowout in border security or lack thereof costs. We had 8,000 unlawful arrivals in the 2011-12 financial year at a cost of almost $180,000 each. So just a huge number of people coming in because of the porous border security policy that we had in place, and then inefficient management once they arrived, because the cost was $180,000 each for taxpayers. Just completely unacceptable, and we should never ever forget, Deputy Speaker, as a mark of shame on the previous government, they then spent $2 million advertising their border security policies, supposedly to people smugglers, including in regional newspapers and radio stations around the country, where I suspect not many people smugglers were active. Now, huge contrast, clear failure in the previous government, clear success from this one. And we're going to add to that success, Deputy Speaker, through the important changes that you'll see in the bill before you this evening. Now, the first is in relation to protection visas, and this is to really make clear a fundamental principle and a fundamental point of law, and that is that the onus in applying for protection is on the applicant to make their case. So the applicant for asylum needs to demonstrate to the best of their ability why they comply with the relevant criteria of the visa that they're seeking to be granted, and then advocate the reason why they believe they should be allowed to receive that visa. And it is not the role of the government or the departmental decision-maker to advocate on behalf of the applicant, because, of course, Deputy Speaker, there's a conflict involved in being both the decider of the outcome and also the person who is advocating on behalf of the applicant. So these changes make it very clear that it is the responsibility of the applicant to put forward their case. Of course, provisions are made for people who are unable to advocate on their behalf, such as children and people with other significant disadvantages. But the general principle is if you are seeking asylum, it is incumbent upon you to advocate on your behalf, and that's entirely as it should be. Now, this other point about the non-refoulement obligation is important too. So you recall, Deputy Speaker, a moment ago I was speaking about the special humanitarian visa category. Now, these are, as I said, people who don't comply with the formal definition under the UNHCR of a refugee, but nonetheless are in desperate circumstances. Now, this group was heavily disadvantaged under Labor because basically there were no spots left for them because of unlawful boat arrivals. But we've now got that group back up to about 4,000 a year, which is a significant intake. And what this clarification says is that the task for the Minister and the Department to consider when assessing one of these applications is whether it is more likely than not that should that person be returned to their home country, they would suffer serious difficulties and significant harm. Now, that was, of course, the test under the 2012 legislation was introduced. It's the same test that's applied in the US and Canada and various other places. But the federal court last year in the SZQRB case changed the standard to what they described as a real chance of significant harm, and that could be as little as a 10% chance. So you can imagine, Deputy Speaker, from a assessment perspective, if the requirement is that if there's only a 10% chance of significant harm being occurring, that means that it would be very, very difficult to differentiate between who should be granted a special humanitarian visa and who shouldn't. So now, by going back to the original intention, which is more likely than not, so effectively 50% plus one, Deputy Speaker, we reinstate that integrity into the system, and we say that it's more likely than not you'll suffer significant harm, then you will comply under these provisions. Now, of course, the other important changes, some technical matters about unauthorised arrivals applying for visas, Deputy Speaker. There were some technical distinctions where an applicant who was on a bridging visa would, in some circumstances, have to apply under a different regime than someone who was also here unlawfully but was not on a bridging visa, and that was really just didn't add any value to the legislation and just created confusion. And so the change here basically means that in the vast majority of cases, unlawful maritime arrivals, when they go through that visa application process, will follow the same process, same piece of legislation, same documents and so on. And finally, some important administrative changes to the MRT and the RRT processes requested by the tribunals themselves, by those tribunals themselves, Deputy Speaker. And they go to things such as the ability to give an oral statement rather than it being required to be in writing, to be able to dismiss an applicant's matter if they fail to show up when they've been given full warning of the matter to be heard, and various other administrative provisions which are important. So, Deputy Speaker, building on an exceptional track record of success, these changes will take our immigration system forward further, and I commend them to the House.